Hi, how you doing? So today's talk is going to be given by Fred Benenson, who is actually a friend and former grader of this class. In fact, I owe much of the success of this class to Fred's booking of Jimmy Wells and Cory Doctorow and Jamie Boyle in this class. And so I met Fred actually in the hallway right outside of this classroom, and he was wearing a hat from an organization that we've spoken about in this class. He was wearing an EFF hat, and it was kind of cool to see a CS student, well, turned out he wasn't a CS student, but to see a CS student wearing an EFF hat. So I just started a conversation with him. Turned out we had a lot of similar interests, and we started working together. Now, Fred also started the Free Culture Club at NYU. We also have Elizabeth Stark sitting here. She started the Free Culture Club at Harvard around the same time. And now he's pretty much running the New York office of Creative Commons, and he'll actually tell us about what they're up to on Wednesday. So anyway, Fred Benenson.
Hey, thanks guys. So yeah, this is kind of meant as a preface to Creative Commons and kind of the future of what's happening with copyright. A lot of people think copyright's kind of boring, but my hope is, and my guess is, after this talk, you guys will find it pretty interesting and start thinking about it a lot more online and how you use it online. So everyone's familiar with that symbol. It gets kind of used everywhere now. But before I begin this talk, let me just first say that this is not a talk or a lecture on intellectual property. I actually don't like that phrase. A lot of people in my movement don't like that phrase either. Intellectual property conflates three different types of law: copyright law, patent law, and trademark law. And while plenty of lawyers use it because it's kind of a fashionable thing to say in the law world, people like to come up with their own phrases. It's actually confusing. If I say, oh yeah, I'm really interested in intellectual property, that could mean I'm really interested in patenting, biomedical engineering products, or it could mean that I am a counterfeit litigant or something like that. So just off the top of your head, or just to start, think of this talk as more of a copyright primer by a non-lawyer. And that's kind of the other disclaimer here, is that I haven't gone to law school. A lot of this stuff is stuff I picked over the last couple of years, just learning myself online in this community. And it's a large part of my job, but I can't say this is actually legally sound advice, and you shouldn't take it as such either. Anyway, moving on. Plato was somebody who created stuff without copyright law, and then copyright law kind of came on the radar when the Gutenberg press was invented. The Gutenberg press was made in 1450, and it allowed kind of mass duplication of creative works. And originally, before copyright law was around, the British Crown kind of had a monopoly over who got to print Bibles, and it was really complicated. And the first real law came about with the Statute of Anne in 1710. But before that really hit, there were all these kinds of authors like Shakespeare and Beethoven, all of who created without copyright. So a lot of the rhetoric in this kind of world will tend towards this argument that copyright necessarily gives authors an incentive to create. And I think, just kind of facetiously having Plato and all these kind of pre-copyright authors work on art really proves that human creativity doesn't really need a legal structure to motivate it. Anyway, Statute of Anne was kind of the first real copyright law in 1710, and it gave you 14 years of protection. And protection is kind of a funny word. It's really 14 years of restriction and monopoly. It classified some work, if you could apply for it, as owned by somebody, and you basically just had the right to control who made copies of it, and that's a copyright. Now copyright refers to a bundle of rights. The Constitution of the United States knew that copyright had incentivized people, or the founders knew that copyright had incentivized people to create work in Europe, but at the time there was no real law protecting copyrighted works in America that were made in Europe. So they kind of acutely understood that having kind of a free-for-all, like a public domain, was important. They were able to kind of pillage a lot of the works in Europe, in America, and teach people them. Charles Dickens was famous for coming over to America and being furious that people are just copying his books. But there was a real tension in the beginning of the States over what should be granted to owners who create things. And this is actually how it's written in the Constitution. And the most important part about the statement is that it says, by securing for limited times to authors and inventors the exclusive right. That's basically saying we're giving a limited monopoly right to kind of exploit your own work, your creative work. And the founders really understood that copyright was a monopoly you were granting to a private interest. And part of kind of America's inception was to fight these kind of monolithic powers. And so they were uncomfortable with that and knew that there had to be a trade-off. And that's kind of like where the public domain comes in. So originally copyright law in the States would last for 14 years. You would have the right to renew and get another 14 years, getting a total maximum of 28 years. After that, it would slip into the public domain. You'd have to do stuff like this. You'd have to put a copyright symbol in the front of your book. You'd have to say, 1799, this PowerPoint presentation's made by Fred Benenson. Not only that, you'd have to make over 1,000 copies and you have to distribute them. This is what's called publishing, and that's actually a very specific term in copyright law. You have to publish and give notification, and you also have to deposit a couple copies into the Library of Congress. This is to prove that you actually copyrighted the work, and you can't. It's also to prevent you from taking it out and preventing it from slipping into the public domain. So you'd actually have to show up at the Library of Congress and deposit your work. And this is a really important part of copyright law, and it was meant to be kind of a barrier so that not everyone would always try to get copyright recognition for their work. And that was important because the founders knew that a rich public domain would help advance the arts and sciences. And so, and they were uneasy about giving a monopoly to private owners. So now, I think it's really better to think about copyright as a monopoly. You're really monopolizing the duplication of work out there. So instead of thinking of it as a property right, which is kind of difficult because you're not actually owning property, you're owning a right to duplicate something. I think it's a lot better to think about copyright as a limited monopoly, limited both in terms of scope and in terms of time. So one of the important things to understand about the nature of copyright law is that it doesn't apply to facts, unoriginal compilations of data. That's basically lawyer speak for things like telephone books and dictionaries, or ideas. And this still holds true. It's been kind of clarified over the years, but there's something called the idea versus expression distinction. And that means if you come up with the idea to make a movie about some cowboys in the West, you have a right to make that movie, and so does somebody else in the room or in the world. What you can't do is take that other person's actual movie and start duplicating it. And this has some interesting wrinkles when it comes down to characters and plots, but the basic notion is that ideas cannot be owned, but the expression of those ideas can be owned. It's called the idea versus expression dichotomy. It means the talk that I'm giving now, the notion of giving a talk on copyright cannot be owned, but the recording of it can be copyrighted. So this all kind of boils down to this interesting little kind of engine of how work gets owned and distributed. And it means if you forget to apply for a copyright when the Constitution was first enacted, your work slips into the public domain. And for a lot of people, that was fine. There was kind of this common sense approach to using work. If not every page of the newspaper was copyrighted, only really big books or not pamphlets were copyrighted. And so it encouraged this really broad, big public domain that people could pull stuff from and build upon. And a lot of Europe's work were in that public domain. In this way, copyright is really meant to be an engine that grows the public domain. And to the extent that copyright grants a limited right to private interests, it kind of balances that by letting those limited rights slip into the public domain. So if you take away one point from this talk, I think that should be this one. Copyright's meant as kind of a carrot on a stick. The Constitution framed it in such a way that it's meant to be a limited monopoly right, which encourages people to create things because they can exploit it and make money off of it, but eventually the work slips into the public domain so that everyone can benefit from it. In this way, I think copyright should really be seen as an engine. So fast forward a couple centuries. This is the Cray 1. I don't know if you'll be talking about supercomputers, but this is what's called a mainframe. We don't really have these in this incarnation anymore, but the Cray one was made in 1976, and incidentally, that was kind of the most significant, one of the most significant parts of copyright history. 1976 is also the name of the copyright statute that changed a lot of things, and it was meant to kind of bring copyright up to date with how people were using it. So hundreds of years passed in American history, and there's some modifications and some extensions to copyright law. But 1976 changes a lot of things, and it's a really important part of copyright history. The laws that the 1976 enact don't actually go into effect until 1978, but I figured this was kind of an interesting and ironic moment because computers are really coming on the scene, and computers, as we'll talk about soon, really changed the face of copyright and the kind of ways we have to think about it. So this is the copyright statute of 1976. If you ever take a law school class or talk to anybody, this is kind of what they'll always be referencing, and this kind of has the most relevant parts to how media works now. And it has stuff to do with like phonorecords and photocopiers and libraries, and it kind of nails out all these peculiar differences and kind of consequences with how media work together in a way to kind of create a more equitable nature of copyright. One of the things the 1976 Act does is extend copyright to 50 years after the author's death. This is really big. I mean, this is going from an optional 14-year renewal to 50 years after you die. And for a lot of people, that'll be over 100 years. And it may be a really long time before anything ever slips into the public domain. There's another type of copyright you can get if you're working for a company or you're working under a contract, and that's called a work for hire. The 1976 Act also extends that, so it prevents even more works from slipping into the public domain 75 years after the work for hire was created. But I think the most significant contribution to copyright is fair use from the 76 Act. Part of fair use depends on this. Part of the reason fair use was created was because Congress was beginning to realize that there was an inherent conflict with how copyright and the First Amendment were working. Arguably, the First Amendment is an incredibly broad and powerful right that we all have, but in some situations, if I want to remark about somebody's book, and I want to say, this book is racist, or this book isn't racist, and I want to do a review, and I want to excerpt it, that comes into conflict with copyright law. And so, in some very real way, the First Amendment right is an inherent conflict with copyright law. Your ability to kind of exercise your free speech rights can be in conflict with somebody else's private property right under the 1976 under the copyright statute. So fair use is designed as kind of a steam valve for this. It's meant to give guidelines for the courts to decide whether a use of a copyrighted work is infringing or not. So they come up with a 4-part test. Wow, I'm going quickly. Stop me if I'm jumping ahead any farther. But I'm gonna have some time for questions and answers, I think. Anyway, so fair use is really interesting because there are lots of interesting cases of cultural works, so that somebody's reusing another person's music and turning it into a remix, or somebody's commenting upon a film and putting it into a newscast. Fair use will determine, is supposed to be meant as a set of guidelines to determine whether or not that use is infringing. But one of the problems with fair use is that you have to wait till you end up in court to actually decide this. And this is a really big consideration if you think you have a right to use a work and somebody else doesn't. The determination of whether or not that will be fair use has to be made by a judge by going over these 4 guidelines. It's not something you can do in advance, and it's not something that's really easy to determine yourself. You kind of have to bank on the judge interpreting it in the right way. So I'm going to slightly paraphrase these. If you want to read more about fair use, you should go to Wikipedia. It has a fantastic kind of section on fair use, and this is because Wikipedia has a really kind of great community who understands the wrinkles of fair use, and they're not lawyers. Like, I'm not a lawyer, but Wikipedia started off by using thousands of images from news sources and other newspapers and bloggers and other people online And a lot of people were justifying that, hey, we should be able to use these things because they're under fair use. The Wikipedia community in some ways is very conservative and doesn't want to expose the Wikimedia Foundation to kind of legal trouble. So fair use images on Wikipedia are only really allowed in very special circumstances. And it's actually a much stricter test than the standard legal test for fair use. This is because Wikipedia likes to encourage people to create their own content, their own photos, and so on. I'm sure you guys heard about that Wikis Take Manhattan thing, which I did over the weekend. Wikipedia only allows fair use images when another image isn't available. So that's a really interesting feature about that community that depends on fair use. Anyway, let's take, for example, I want to review a book in a article, and the question is, how much of that can I excerpt? I'll just kind of go through the purpose, or the 4 steps here, and try to give examples of how a judge might kind of evaluate my use of the book or the sections of the book. First is the purpose and the character. The reason I have a school bus up here is because kind of non-profit, non-commercial uses of copyrighted work are not looked at as harshly as for-profit uses of a work. So it means like this photograph, except for it's licensed under Creative Commons. Say I just grabbed it from the internet. Since I'm kind of using it in a non-profit, non-commercial setting, it's a lot kind of more likely that a judge won't be as harsh on my use of this. I'm not trying to sell it to you guys. You guys aren't being charged. Well, you are, but I'm not personally charging you for access to this class. It's not really going into my pocket. I'm not getting paid for this. I'll put it that way. So the purpose and character of a work is kind of the first step, and that can go a long way in determining a fair use case. Next is the nature of the copyrighted work, and this is kind of a vague way of putting like how it gets published. So if you're directly competing with somebody, not even in a kind of market sense or an economic sense, but if you're just like making the same book and you're printing it in the same format, then that's not kind of as justifiable. But if you're, say, making poetry out of, Dickens or whatever it may be, or you're making a screenplay, or you're making a collage out of a work that's originally a photograph, the kind of resulting work is kind of substantially transformed. And so this is sometimes a test for what's called transformativeness. I'll give some more examples when I get to the end of this. I like to use a pool metaphor for the amount and substantiality. Think of a pool as not only being like wide and long, but as being deep. So a lot of fair use tests will depend on not quite how much of the work is being used, whether it's a couple dozen sentences, but whether the essence of the work is being used. And so the kind of depth of a sample of a copyrighted work really matters in these cases. And this is primarily in music cases where a melody hook gets used from a song. Is it the kind of core of the song? Are you taking the 3 or 4 riffs that make the song famous? And are you using those? Can I get some water? Give me a chance. Are you using that to kind of push your song and make a remix out of it? Or are you just grabbing a drum loop that nobody would be able to recognize? So while it does matter how much of the work you're taking, it also matters in what way and kind of how deep you're taking it. So finally, the last test is the effect on the market. This is meant to be a test to see if you are competing with the original work. So if you're actually going to market with yours and trying to compete, is somebody going to go try and find your version and resell and buy that instead of the original? Are you competing with the original? And so these are meant as guidelines that the courts are supposed to kind of interpret as ways to understand if your new version of a work is infringing on the old version. And in the case of kind of reviewing a book for an article, just think about it. The purpose and character, I'm trying to give a review that's kind of established. I'm not essentially competing with the original book. The depth of the book, I may take a really significant portion of the book. I may say, this character does this. Romeo and Juliet kill themselves at the end of Shakespeare. That is in the essence, I'm sorry if I ruined it. but that is the essence of Shakespeare. It's a lot of the book, but it's also kind of important for a review on the book, right? So there are a lot of kind of considerations here, and they're kind of now boundaries that people kind of accept as part of fair use. They're not really hard and fast. And a big problem with fair use is that it's kind of a gray area, and you have to rely on a subjective judge's interpretation. And it's one of these really funny situations where we have to let the courts kind of decide what is okay art and what's illegal art. And that's a very strange thing. And this is kind of one of the very interesting absurdities I find in copyright law, is that as much as America wants to leave kind of subjective decisions over what counts as culture or not, and as libertarian we are in those situations, there are and will continue to be many situations where a court decides that a painting is illegal because it uses too much of somebody else's. And in that way, we have this very uncomfortable relationship with how our culture is mediated by the courts in some situations. Next. So that's a marketplace. Skip that one. So like I was saying, there are a lot of kind of boundaries that people have kind of come up with as kind of ad hoc ways to think of fair use. One is parody, and this is kind of receives the most amount of attention. So this is just something I looked up parody on Flickr and found this. And you know, everyone recognizes these ads as being iPod ads, and there are a lot of weird and funny spin-offs of these ads, and it's like, well, obviously the person's using the original work. In a way, the character is kind of different. It's meant as kind of a commentary. I'm not sure exactly what they're trying to say, but maybe electronics kind of, I don't know, entangle us and the objects we own, I don't know, threaten our lives or something. Or maybe it's just a child safety thing. You know, those 5-gallon buckets have this too. But parody is kind of routinely considered one of the most important parts that's protected under fair use. So this means you could do a song that's mocking Barney the dinosaur by saying Barney's really like a middle-aged man that's probably balding under that suit, and you can just, you know, rephrase those lyrics to that song. What's interesting is that parody is actually protected more frequently under fair use than satire. And a lot of people think parody and satire are kind of the same thing, or never even bother to think about the difference between parody and satire. Does anybody know? Besides you two? Do you know? So the difference between parody and satire is that parody means you're using the work to criticize itself. And in a way, when you think about it that way, it makes sense that it's protected so frequently, or it's found to be a fair use so frequently. Because how would you criticize Barney's theme song without actually using Barney's theme song, right? How would you make a joke or kind of a similar work without actually using the original theme? Satire, on the other hand, is when you're using somebody else's work to make a commentary on something else. So it's like I could remix clips of, let's say, Barney the criticizing George Bush. And the courts don't look, and traditionally the courts don't see that as protectable under fair use, or as frequently protectable under fair use. And the justification is that the work could have been created by you, whereas in the original case of parody, there's no other work you can use, and parody is left open because, you know, institutions like Apple's iPod advertisements should be allowed to be criticized. This kind of goes back to my point about the inherent tension between copyright law and freedom of speech. Like, we wouldn't really consider us to be living in a free society if the government said, I'm sorry, you can't do that. You can't make a joke about Apple's silly advertisements. So we want to protect people's ability to criticize other forms of art out there. But on the other hand, we want to encourage people to create their own new work. So if I was just going to use Apple's work to, you know, use the same style and the same font face and that stuff to talk about, I don't know, let's say they did Abu Ghraib ones, right? Where they had people like with the, you know, the really politically charged photos from Abu Ghraib in the same kind of formation with the silhouette. Arguably that's a satire, it's just using Apple stuff. And so this is, you know, it's still a judgment call, it's a little bit closer to parody. So another thing that's kind of falls under fair use, or used to fall under fair use, there are now court cases that significantly undermine this, is the idea of remixing music. Taking one track and putting it into another, changing the character, and that kind of thing. There's actually a really significant court decision because it traumatized the music world. Is anybody familiar with Bridgeport music? It's only copyright nerds know about it. But there was a holding company that was going around collecting ownership of samples. I'm going to forget the exact sample. Is it what's his name? Who is it? George Clinton?
Clinton,
yeah.
Your acid jam.
Yeah. So there's a good movie you should watch called Good Copy, Bad Copy. You can download it for free. That talks about this. But briefly, there's a copyright holding company that was going around and just buying up rights for works, and they were just banking on the fact that somebody would use one of these songs in a new song, and they could sue that person, and the record label will make a lot of money. And
Actually, people had already used the songs. They were aware that
they knew it, and then they went and bought the rights just so that they could sue. Two Live Crew was the name of the band, the rap group who ended up using it. So it's just this one little kind of catchy hook that gets used in the song, and there's this whole lawsuit, and the judge then decides. The opinion was, if you sample, you license, which means if you sample another person's work, you have to pay what's called a compulsory license. And there is no room for fair use in music sampling anymore. And granted, this wasn't a Supreme Court decision. This was in one particular circuit. It is really significant now, because where I would be able to use a person's book in my own book to comment about it, it's not really clear that I can do that anymore for music. To the point about compulsory licenses, if you guys were here for Tim Westergren's talk about Pandora, he was talking about how they can pay a certain rate to the record companies to be able to stream radio over the internet. The idea behind compulsory licenses is that the artists don't have a right to tell you can't use it. There's an established rate that Congress and the record companies agree on. You just pay that rate and you can use it. The fight in the Bridgeport case was over whether or not you would even have to pay that rate. Anyway, fair use arguably applies in a better world to remixes, but the prospects are grim now for musicians and fair use, which is unfortunate. You guys like Girl Talk? Anybody have his new album? So, Girl Talk is a really interesting case. He samples only the hooks from popular music, right? So it's not like, the depth question over how the character of the work, are you taking that part? Yeah, he is. He's taking every single part and jamming them all together. The interesting thing with Girl Talk is that he hasn't been sued yet, and this is his claim to fame, is that like nobody's gone after him. And one could say, well, that's because he's probably not that popular, and they don't really smell blood because his record company isn't really a record company. It's just a front so he can release music. But on the other hand, it may be because the people who own those rights, or some of the people who own those rights, see what he's doing as kind of interesting and innovative and maybe even a fair use. Girl Talk's label's called illegal art for a reason. He can't really sell that album in stores. I'm not even sure it is sold in stores. He just offered it up for download, and you pay what you want, which is great. Let me show you my cards. But is it fair use or not? I know this is something Stark and I have gone back and forth about many times, and it's a really controversial point. Is by kind of our intuitive standards, yes, he's creating new work. It's incredibly innovative. It should be fair use, but by the kind of legal standards, it's definitely not fair use. This is kind of the example I've been using a lot. This is just some dude on television. Television uses clips of movies and that kind of thing all the time, so they can talk about the movie, review the movie. They can show you that YouTube clip that like some kid, jumping onto a trampoline off the roof, because it's newsworthy, right? So that's frequently used as a test for fair use. One of the things that before I get to that one of the things that got me interested in starting like a student movement about this, and I had already been kind of thinking about it, but there was a case involving some students in Swarthmore College in Pennsylvania who had been distributing a memo about a voting machine corporation called Diebold. Have you guys gotten into voting machines yet? I know you're going to be getting there eventually, but so it's no secret that voting machines are very controversial. Electronic voting machines, that is, and the company's now the company Diebold is now kind of given up on making them because it's such a difficult thing to do right. Diebold has a lot of issues. I'm going to try to be specific, but one of the things they did was sell the state of California voting machines that weren't certified properly, and they admitted to this internally, and they knew this, and they were just going to try to flub it, or I don't know, avoid telling anyone about it. But there was somebody who was looking around on their website and found an open directory of files, and it just happened to contain thousands of internal memos of Diebold's internal communications talking about this fact. But they didn't know that yet. They just found thousands of memos, right? So they started distributing it on the internet, and it got around on the big news sites, and this is probably late 2002, maybe late 2003, when this was happening. And eventually somebody discovered this fact, and the memos became even hotter as a kind of item, and Diebold was kind of like facing a lot of trouble. They were basically, it was the smoking gun. One of the groups that was hosting it were these kids at Swarthmore, and they were part of an anti-war network, and they were hosting it on their school server account. You guys probably get like NYU accounts that you can upload stuff to. I know I did. So they just put it up there, and they quickly got a letter from Diebold's counsel saying, you can't do this, you're infringing on our copyright, which was kind of weird, because it's like, okay, I guess you can claim creativity in the memos and that you deserve copyright protection. Anything that's kind of fixed now, I'm getting to this other part of the 1976 statute, but those memos are our copyright, was what Diebold was saying. You can't distribute them. So they hired a lawyer from the EFF. They didn't exactly hire. They got a lawyer from the EFF, and they proactively sued Diebold to establish that their distribution of the memos were fair. It was a fair use, even though they were copyrighted. It was because the memos were newsworthy, they had information that was of public interest, and despite them being the entire memo, and there's no question about the kind of the depth and breadth of their copying, they still had a right to do it. And so this is a big part of fair use, and it's one that's kind of frequently protected by journalists, but journalists are also not as frequently using fair use anymore either. And then perhaps one of the most interesting fair use cases was your right to make videos and time shift and format shift the media that you purchase. This is an advertisement for the Sony Betamax. Who knows what a Betamax is? Okay, wow, 2 or 3 people. So Betamax was one of the competing formats to the VHS. It was the HD DVD for VHS's Blu-ray, if that makes sense. But Blu-ray's not doing that well anyway, so it doesn't even matter that much. But Betamax died, and part of the reason was it was expensive, it was bigger, it wasn't as easy to copy, and the VHS kind of beat it to the bottom in an interesting way. And this is kind of a theme in how format wars work. But when Betamax came out, it basically, the basic platform of their advertising was that you can watch whatever, whenever you want, and this means you can record live television. And I know we're all kind of brainwashed by how available media is. I can go look up any Daily Show episode that's ever been aired and watch it immediately. There was a time when your ability to watch television was strictly mandated by TV Guide, and that was it. And so this was blowing people's minds, right? This is like, this was bigger than TiVo and iPod combined, the fact that you could record what you wanted when you wanted. And very quickly, the content companies, the television corporations realized that this undermined their fundamental business model. The fact, not only could you watch TV when you wanted, and you didn't have to watch it during prime time or whenever it may be, you could also fast forward through commercials. And this, they saw, was the kind of downfall of their business model. Not only that, you could record movies, so you didn't even have to go to the movie theater. So there was a big fight. It went to the Supreme Court. The Supreme Court ruled in favor of Sony, which is ironic because Sony would find themselves on the other side the fence 10 or 20 years later. They ruled in favor of Sony, saying that because the Betamax has what's called, quote, substantial non-infringing uses, we should allow it, and those uses are fair. The idea that you can time shift or format shift the shows that you want to watch. So Sony Betamax is kind of the case that a lot of people measure things like the MP3 up to. And there was originally when Creative, which is now not as big of a company, not as big of a leader as they once were, Creative had made the first MP3 player and brought it to market. The way that the judge decided whether or not an MP3 player was legal was based on Betamax. There was substantial non-infringing use for an MP3 player, and we all know that now, but Betamax is a huge, huge case. So like I said, this is all kind of within the scope of the 1976 Act. One of the other things that the 76 Act does is establish first sale doctrine. And this is what enables like the Strand bookstore, which I'm sure you guys are all familiar with. In case you aren't, the Strand is a staple of New York City used book scene. These are books that are selling for $1, but if you go inside, they have really nice books for like $30 that otherwise cost like $70. But they're all used or secondhand or kind of not necessarily the first time they've hit shelves. But if I'm sure you probably haven't even thought about the idea of copyright versus reselling a book, right? Like you're not selling a copyright, you're just selling an individual object. So the first sale doctrine says you're allowed to do this, and it's a little difficult to figure out what it actually applies to. Like when I look up Photoshop on eBay, I only find new versions of Photoshop, and this means I can buy a copy of Photoshop and then resell it to you, as long as I haven't opened it. But there are actually all these weird wrinkles over whether or not you can rent things like software and music, and you used to be able to rent like software, but this is problematic for the business model, and there's also like legal questions. And do you know, like it's really complicated what the kind of nature of.
Or is it ruled that there's no digital first sale doctrine?
Yeah, that doesn't surprise me. I mean, the first sale doctrine also prohibits reselling of CDs, but there was a workaround for that. Anyway, first sale doctrine's incredibly important for physical media, but it's also really complicated for digital media. If you put your iPod on eBay, are you obligated to take off the MP3s? I mean, you still have them on your computer, but you want to sell the iPod player. What's like the exact legal kind of question there? And you're probably committing copyright infringement. I mean, I'm not a lawyer, but it's kind of clear, but it's also really unintuitive. Like, why should I have to like scrape the music off my iPod just to sell it? So I'm almost at the end of the copyright history, and then I'll start talking about more up-to-date stuff. The Berne Convention was actually something that was made in the 19th century that America didn't agree to until 1988. And these are now the countries that kind of agree to the Berne Convention. And it's basically an attempt at synchronizing copyright laws across the globe. It also contains a lot of other interesting facts or kind of laws about how copyright will work. One of the things it says is that you don't.
The blue ones agreed to it.
Yeah. So, I mean, except I don't even know what some of these countries are. Looks like Malaysia, Iraq, probably. Is that
Burma.
Andorra? I don't know. You can barely see it. So one of the things that the Berne Convention says is that you don't actually have to notify the Library of Congress that you've created something in order to get copyright to it. And this is a big deal. Before the Berne Convention, you would have to send a copy to the Library of Congress. And you still have to register your work if you want to sue somebody over it, and there are other formalities involved with notification. But the notes that you're writing now are copyrighted. More importantly, there's no need to put a copyright symbol on there. You don't have to publish it. You don't have to distribute it. This means that the notes that you are writing now, again, are copyrighted until 70 years after your death, so long as they're marginally creative and original and fixed in a tangible form. They are yours, and you can exploit them as much as you want. So what does that mean? That means you can sell the rights to reproduce the work, you can perform it. There's this whole bundle of rights that copyright speaks about when it says you have exclusive rights copyright. 1998, the Sonny Bono Copyright Term Extension Act was passed. This is also known as the Mickey Mouse Act. Mickey Mouse, the copyright, the underlying copyright, not the trademark mouse or the logo or anything, but the Steamboat Willie himself, the movie itself was about to slip into the public domain, and Disney was worried that people were going to start creating derivative films based on the character of Steamboat Willie, Mickey Mouse. So they heavily lobbied this congressman named Sonny Bono, who also happens to be had been the husband of Cher. He died in a skiing accident a number of years later, to pass the Copyright Term Extension Act. So this pushed it even farther. I was saying before, 70 years after your death. And this is actually even farther than that. Works for hire are now 120 years, depending on when they get published. So this means if you happen to find an unpublished work, and correct me if I'm wrong, I think this is right, if you happen to find an unpublished work that was created in the last 30 years or so, and then you publish it now, it is then ownable for 120 years, which is an incredibly long time. This is a graph from Wikipedia that shows you the terms of copyright law and then how you can kind of try to figure out whether or not a work is in the public domain or not. It's actually kind of hard to read. It's confusing because there's this little green triangle thing here, and my understanding is that that is for works that were created in that time and were now are slipping into the public domain, but could have been registered and haven't been. It's actually incredibly difficult to determine whether or not a work is in the public domain. You have to do a lot of research. There are people who spend all their time doing research as hired by content corporations or libraries to try to figure out who the actual rights owners are for a particular work. This gets to this problem of orphan works. There have been hundreds of thousands of books published in the last century. A lot of these books only get published once. A lot of those books are just like sitting somewhere rotting, and you may have a couple on your bookshelf or whatever. But chances are the rights to publish those books have been resold a number of times down the line. And it's actually unclear who owns those rights. And you'll end up in these situations where two publishing companies will claim that they own the rights to publish a book. Or the same two publishing companies will disclaim the rights to disclaim owning the rights to publish a book. And it's actually incredibly difficult to determine who is the owner for a large majority of books because they never make it past the first edition. The orphan works problem is a huge one, and it's kind of what got people interested in the copyright term extension problems, because we're looking at vast swaths of American culture and world culture that we have to presume are owned, but we're not sure who the owners are, so we couldn't even license them if we wanted. This is a really cool graph I found making these slides today. These don't show absolute numbers, but relative growth. Peter Yazzie, who filed this on behalf of Lawrence Lessig when he was suing the Supreme Court over the constitutionality of the Sonny Bono Copyright Term Extension Act, Lessig was trying to argue that by extending it even farther, you've essentially made copyright unlimited. And that's in direct contrast with the Constitution, which says copyright has to be limited. So this is the amount the public domain, the rate of growth of the public domain at every point when copyright terms got extended. So you can see the growth. Let's say it goes from 0 to 10 on the y-axis. In 1831, right before a copyright statute got enacted, let's say the rate of growth was 30% for the public domain. That means a lot of work was. Yeah, sure. Yeah, it's pointing at the screen. All right, y-axis. Let's say like 0 to 10. 10 is up there. So around here, let's say it's like 30% of works are passing the public domain in 1831. That's great. That's kind of the point of the Constitution's copyright statute. But then another 14 years pass. Well, that's not 14 years. It's just naming the type of extension. But 1909, the rate of growth of the public domain is even smaller and smaller, and now we're in 1998. And this is how fast the public domain is growing. And Peter Yazzie extrapolated that if none of these terms got extended, the public domain would be growing at 90% a year or something like that. So by extending, it's a little difficult to grasp the point of this chart if you don't if you're not kind of steeped in these issues. But by extending copyright terms every 10 or 20 years, another 10 or 20 years, Congress has essentially stifled the public domain. Works no longer pass in the public domain, and they won't until 2012. Right? I think 1923 is the date that you can be sure a work will be in the public domain. But after that, it's kind of up in the air. So since this is a Computers in Society class, I figured I'd talk about software and copyright before we kind of get to the internet and copyright. First, do you guys have any questions? Lots of ideas. I'm trying to slow it down. So what's protected under copyright in terms of software? This is source code. I don't know if you guys are kind of on this part yet, but computers run something called object code, which looks like this. That's annotated by a human. If you ever take a computer science course and you study assembly, this is very much what your notes will look like. These aren't mine, but they look pretty much like this. But then what you actually write if you're not taking an assembly class is source code that kind of looks like
Source
this.
versus object.
Right. So, you've been over. Great. So you guys know what I'm talking about here. This is written in C or C++. This is some source code I grabbed from a video encoder. If you program, your stuff won't look anything like this, but the point is, this is what humans are supposed to be able to write, and this is what gets compiled into this. So both of these things are copyrighted. This means source code that you download from the internet that somebody else made is ownable by a human being, as well as the object code that the computer's processor interprets. So what's not protected is just a screenshot of my computer making this presentation. The look and feel of an operating system. You'll see the icons and the logos, like the Photoshop logo and the Apple icon are ownable. I mean, Photoshop owns that, Adobe owns that, Apple owns the Apple logo. But the look and feel of the interface isn't actually ownable. And there was a big fight over this in the 80s. Mitch Kapoor, who had started Lotus, which is now kind of an office suite that not as many corporations use anymore, tried to sue a number of other companies who were making programs like word processors and database, Excel type applications for copying the look and feel of his application. And he argued that a drop-down menu like this, where you put new under file, is kind of a creative expression. The courts ruled against him. They said, well, no, that's so utilitarian. It's not really ownable. It's not copyrightable. So this is why people are able to make kind of open source clones of proprietary software. Like Firefox kind of looks and feels like Netscape Navigator did, which looks and feels like Internet Explorer. And despite kind of having the same interface, they can kind of be distinct works under the copyright statute. Another thing you can't own is ideas. This is just some whiteboard. I kind of was talking about this, but the fundamental nature of a program that deals with images, that allows you to crop them, that kind of thing, you can't own that either. So this is all kind of important to keep in mind when we kind of talk more about software and copyright. So then we get to the internet, and this is what somebody's kind of artistic interpretation of the internet is, but what the internet really is a big copy machine. Thousands and thousands of copiers that all they do is just copy things. When you download something from the New York Times, you're not actually transferring an object over the internet, you're duplicating content at each step of the way, and by the time it hits your machine, it's already been copied thousands of times. It's in thousands of computers' kind of memory, and it will be in thousands of copies on your computer's memory. So this obviously poses problems for the kind of inherent nature of copyright law. If copyright law is designed to kind of legally protect owners from people copying the work, it kind of stumbles in the face of the ease of copying that the internet presents and digital computers present. So in an attempt to kind of remedy this issue, there's the Digital Millennium Copyright Act in 1998, which Bill Clinton signed. And when I first got into this whole thing, the DMCA seemed really evil. I'm going to talk about why I thought it was so evil, but there's actually a kind of a silver lining to this cloud, which I'll end on in a bit. But the first kind of interesting case that the Digital Millennium Copyright Act involved was the 2600 versus the MPAA case. it wasn't actually called this, but 2600 was a magazine that published source code from a DVD player. And MPAA is the Motion Picture Association of America. And this is kind of what got me interested in this whole mess. This case was amazing and really interesting. You guys familiar with Linux? The notion, it's a do-it-yourself kind of operating system. A lot of people collaborated together, are still collaborating, making many different flavors. But the idea is to write the same basic components that Microsoft or Apple writes and run it on hardware of your choosing. And there are a lot more philosophical reasons for why people participate in Linux, but for the sake of this discussion, let's just assume that you have to write your own software for Linux, and that's what was happening. Well, when the DMCA came around, DVDs were just getting popular, and people were buying computers from places like Dell and Gateway, and they're coming with DVD players, and people were starting to create DVD collections, and they wanted a player for Linux. And there was this question over how would that happen? And everyone's like, oh, we'll just write our own player for Linux. But the problem is that the way the motion picture industry decided to release the DVD specification was that they would encrypt the DVD using keys. And these keys turned out to be really easy to break, but initially they thought this would prevent people from making copies of DVDs. It was an erroneous assumption because it turned out to be really easy just to make a copy of the whole DVD with the encryption included, so you just have the same keys on 1,000 DVDs, and it wasn't a problem, but they thought this was going to prevent people from sharing the DVDs online. But it turns out if you want to make your own DVD player, you have to decrypt the DVD, right? Like humans can't read encrypted data yet. So in some way it has to get transformed into readable data by humans. So this happens naturally inside your computer when you have a licensed DVD player, but the MPAA is very stingy about when they were going to let and who they were going to let decrypt DVDs. So they kind of controlled the keys to the whole building in a sense. And they weren't going to let Linux write their own DVD player. They were just like, Linux is this scary world of unwashed computer hackers. We're not going to give them the keys to write their own DVD player. And so the Linux community was pretty annoyed with this and started writing their own version anyway. The guy on the left, Jan Johansson, ended up figuring out the algorithm, and it turned out it was pretty easy to break. He was a 14-year-old when he did it, and he was in Norway. And besides posing some interesting jurisdictional problems, it was kind of a big deal at the time. The kind of the lock had been broken for DVDs everywhere. It turned out that it wasn't that difficult to break, but now that this 14-year-old had the basic components of the encryption down, development could continue on the DVD player for Linux. 2600 is a hacker magazine which then published the source code. Oh my God, don't look at it, it's illegal. The source code enabled anyone to decrypt a DVD. And that means you could play it in Linux and watch your DVDs, but it also meant that you could copy it. Turns out the Digital Millennium Copyright Act had a specific provision saying you're not allowed to write what's called circumvention devices or technologies. You're not allowed to even create them, you can't talk about them, you can't share them, you can't link to them. And there were some serious First Amendment implications with that law, and 2600, the hacker magazine, was determined to challenge them. They published in their magazine. MPA said, you can't do that. They said, all right, well, the issue's done, but we're going to link to it online anyway. We're going to host it online. They said, you can't even do that. That source code is too dangerous, and it's going to destroy our, industry and so on. It turned out the DVD was like the most popular format ever, but they were incredibly angry about this, and they kept on fighting 2600. They went to trial over whether or not 2600 could even link to the source code on another website. The MPAA claimed that it was illegal to traffic in circumvention devices, and that means you can't even link to this, maybe 1,000 lines of code. And people were able to get this code even shorter than this. This is the original.
The law said that it was illegal to traffic, and
right.
it was a matter of what it meant to traffic.
Right. The fight was over whether or not linking to the source code was considered trafficking in, and that's kind of an interesting problem. But I could, I was in high school when this was happening. I could tell there was kind of like, this is kind of a big deal. And it was kind of like really strange that A magazine couldn't publish what they wanted. I thought that was part of the First Amendment. And B, that there was this, sounded like a really bad law on the books that was protecting really bad technology. So 2600 lost that case, and they went to appeal, and they lost that part. And they were, the settlement, the decision was that 2600 couldn't link to it, but they could provide unlinked hypertext URL, or a non-linked URL on the page. So they could say, you know, it'd be the equivalent of saying, you can go to www.google.com, or you can, like that's okay, but you can't put the link inside the hypertext, which was an absurd decision, to say the least. And at this time, I was like, wow, this is like a really weird law. This guy's Dmitry Skillerov. He was a PhD student in Russia working for a company called Elcomsoft, and he went over, he came over to Las Vegas to give a talk at a hacker conference called DEF CON about how to decrypt Adobe PDF files. So you may not know this, but you can encrypt Adobe PDF files not only to prevent them from being opened by other people, but to prevent them from being copied and that kind of thing. So it's got this whole what's called digital rights management system built in. So Skillerov was the person who cracked that code. As soon as he finishes giving his talk at DEF CON in Las Vegas, CIA agents arrest him, take him to jail, throw him in jail for like 2 weeks. His family doesn't know what's going on. People start protesting. I was kind of helping organize the protests in New York City, that they arrested essentially a computer scientist for giving a talk on encryption. And it turned out Adobe kind of freaked out and jumped the gun, and they probably shouldn't have. And then they kind of backed down because they realized it was a publicity nightmare. And Skillerov was being charged as with trafficking a DMCA violation by giving a PowerPoint presentation. But once Adobe dropped the charges, the CIA didn't want to look like they were kind of like playing by Adobe's rules, so they kept on pressing the charges. And he stayed in the country for another couple months or something. It was like really strange, and eventually he was totally exonerated. And they're still selling the software, but Adobe's DRM has been cracked for years at this point, and that was kind of late 2001. Now, kind of fast forward, and this is the flip side of the DMCA. That's really interesting. DMCA provides, among other things, it's a big law, it's a big amendment to the copyright statute, but one of the most interesting things it does is it provides safe harbors to ISPs. And what that means is if you're somebody who's providing content or posting content on the internet, you are not responsible for that work being infringing or not unless somebody tells you about it. So if somebody happens to upload MP3s or let's say Daily Show clips to your website, you're not really responsible for keeping track of whether or not that's infringing content. The person who's responsible is the content owner. So I thought this was kind of a pertinent thing because the guy's saying fight for fair use. Apparently this is something to do with NAMBLA. I don't really know what's going on there. But the interesting twist was that when YouTube became popular, it was because they were hosting a lot of infringing content, right? Like everyone was like, oh my God, I can go to YouTube and watch The Daily Show, or I can go to YouTube and watch America's Funniest Home Videos, or, you know, and I'm sure you guys love that show. But there was this whole swath of infringing content, and the reason why YouTube got popular, and there were a lot of other sites competing with them, was because they were waiting the absolute limit until they had to take it down. So with the DMCA, there's something called a takedown notice. You guys have probably heard about that. If you go to websites like Gawker or Slashdot, or even YouTube, you go to the bottom of the page, it says DMCA takedown notice section. And that page tells you how you tell YouTube that they have infringing content. So you say, YouTube, you have a clip of The Daily Show, it's here, you got to take it down. It's a little bit more formal than that, but then YouTube is then obligated to take it down. It turns out YouTube doesn't actually have to check to see if you're the copyright owner or anything. So it's not good for that reason, but it allowed YouTube and even sites like Google to really grow. Google depends on copyright infringement in a way. The fact that they have to make a copy of everyone's page on the web in order to analyze it for links and text and do analysis to properly rank pages when you search for them means that they have to make a copy of it. So in theory, you could tell Google to stop posting your content. They have a whole DMCA section, and they have to listen to you under the law. But this part of the DMCA was seen as a way to help internet sites grow organically. And so this fight with Viacom is over whether or not YouTube should have to be responsible because they're committing more than, quote, $1 billion of copyright infringement. Viacom actually said that in their complaint. They're suing Google and YouTube over whether or not the DMCA should have to apply for them. And so this is this big open question. Is the onus on Google or is the onus on YouTube? Viacom. And Viacom says there's so much infringement, we couldn't possibly determine that. We couldn't possibly go through every page and say, this work is infringing and this work isn't infringing. The onus should really be on Google. And Google says, well, listen, you're the people who care about it. You can't just tell us not to do what we do. You have to be specific. And so they're in the Southern District Court of New York fighting over it. And I've been to a couple of cases. It's pretty interesting. My feeling is that it would be really problematic to have this part of the DMCA overturned. Even sites that we run as Students for Free Culture depend on the fact that we have to be notified if somebody uploads. The content holder has to notify us if somebody uploads their infringing content. We don't have the manpower or the willpower to keep track of it, and a lot of the internet kind of works that way. So that's kind of it. I've managed to fill up my hour. I'm going to be talking more about the kind of proposed solutions to a lot of these problems on Wednesday, and kind of where they came from, the Free Software Foundation, Free Culture, which is kind of the student group that I'm organized in with, and then Creative Commons, which is my employer. Those are all the credits for the photos that I used. But we should probably get to questions if I haven't bored you guys to death by now. I hope that kind of gives you a better understanding of copyright law. That was the first time I did that deck. I kind of rewrote it for this talk. So, yeah.
Any questions?
Yeah.
The Wendy Seltzer case where she put the thing up on YouTube of the copyright thing, what happened with that?
So Wendy Seltzer's a kind of lawyer in our world who's done a lot of great work, and she had previously worked with the EFF, but now she's back at Northeastern University. Is that right?
She's at George Washington.
She's at George Washington now, but it was a fantastic example of what fair use and the DMCA, the issues with fair use in the DMCA and YouTube. Wendy had specifically uploaded clips of the Super Bowl from last year to YouTube to show to her law school class that she should be allowed to talk about the NFL in a video on YouTube, and it shouldn't be taken down. But one of the automated robots on YouTube decided that the content she was uploading to YouTube was infringing and it had to be taken down immediately. And it precisely proved her point that the DMCA is flawed in the way that anybody can send a takedown notice. And I mean, you can't fraudulently claim that you're the NFL when you're not, but you can fraudulently claim that a work is infringing when it's not. So
She put up the copyright notice, specifically the NFL copyright notice.
right, yeah, you got the detail that I forgot. The reason she uploaded this particular clip of the NFL was that the NFL was putting this copyright notice into the frame during their broadcast that said you're not allowed to broadcast this under any reasons, you're not even allowed to talk about it. It was an example of an overly restrictive copyright notice that she wanted to talk about in her law school class. And so sure enough, the NFL told YouTube to take it down, and YouTube took it down. But Wendy's point was to put it up there to show her class that she should have a right to talk about it and not use it. It wasn't like she was rebroadcasting the Super Bowl. So they went back and forth, and eventually YouTube relented and let her keep it up there. There's something called a putback notice, which is the kind of other side of the coin of the takedown notice, which you can file with YouTube again, and YouTube's just an example here, to say, it is actually fair use, why don't you take a look at it again? And then I think YouTube has to honor it. But
it's called the counter notification.
Counter notification.
And basically you have, there's a 10 to 14 day period during which, so say I'm Wendy Seltzer and I put something up and then it gets taken down. I file the counter notification, YouTube notifies the person that filed
Right.
the original notice, and they can sue me within 10 days. If
Right.
they don't sue me within those 10 days, then YouTube puts it back up.
Right. So these are all kind of ways to design the Digital Millennium Copyright Act to kind of enable fair use, but they don't always work as well as planned. So.
Can I have one comment
Sure.
about the DMCA? Essentially what it is it's a safe harbor, so it's saying that YouTube is not liable to be sued for copyright infringement if they abide by all of these terms. So YouTube could just wake up tomorrow and say, all right, forget it, we don't want to use the DMCA, we're going to do our own thing, but then they're no longer eligible for the safe harbors, and they can get sued by Viacom. Viacom here is arguing that YouTube shouldn't be eligible for this.
Yeah.
And they have a variety of reasons why not. But a lot of websites, if they don't have policies for the DMCA and if they don't abide by what's in the law, then they could just, in theory,
Get
sue for what's called secondary copyright liability.
Right, which is when you're encouraging people to copy things. So that's what people are trying to go about against the file sharers for. Yeah.
I guess I just want to clarify something. When you were talking about the Berne Convention and how that changed things so that you didn't need to put the little C on your work, you didn't need to apply to the Library of Congress, that basically anything that you do or write is copyrighted immediately?
Immediately.
Wow.
To 70 years after your death.
So then if someone steals your work, how do you prove that you're the original author? Then you just take them to court?
Then you do have to notify the Library of Congress. You do have to kind of go through notification, but you would prove it any other way. Like you would have evidence of you being in this classroom, having taken these notes.
Yeah.
And, it gets tricky, but you're maybe grasping at this problem of where two people kind of create a similar work without knowing about it, and that's actually like an unresolved problem of copyright in general.
Copyright says that you can have two separate copyrights in those works,
Right.
unlike patents where you have
Right.
to have to.
But it's still problematic in other ways. But
I think many things are problematic
Yeah.
in the age of the internet.
yeah.
I'm a favorite when it comes to the free culture stuff, which is how I ended up here in Forgive the Suit. I'm someone who started in old media in the 1970s as a producer and has drifted into new media in the last probably 15 years. And one thing I think is critical to understand is that when the Betamax came out, Sony and large companies or movie companies, the decisions that they made, people have to understand that the conceptual paradigm is entirely different. So what's critical is that everyone in this room, except for me, and maybe everyone, I'm not sure, grew up at a time when actually publishing and copying was extremely difficult to do. So I once heard Daniel Ellsberg say that, if the Xerox, if he had had more access to a Xerox machine, the Pentagon papers would have been published a hell of a lot earlier because he could only go into Xerox a couple of pages at a time. And so that whole concept, basically right now, you guys live in a world where, I grew up in a world where my tension against anybody's copyright was almost irrelevant. It really never occurred.
Right. That's
and so what's happened is it's not just sort of the Ted Stevens, the internet is a bunch of tubes world, but all of these laws and all these concepts and people who are still writing these laws, grew up with an entirely different paradigm. And I just think that that's critical as you look at that. I worked at the networks, and when the Betamax came out, the tech guys knew about them and just sort of said, God, they're so much better than VHS. But they were $1,000, $800 a piece. It's not like people shouldn't be under the impression that everybody had a Betamax, and that's why the movie studios went and did this. They did this because they saw what was happening, and the average person didn't, as opposed to where you guys live.
I think that may have been true for Betamax, but in a way, it's different for how MP3s or Napster worked. People, that took them by storm. They're still fighting against, MP3s, which is crazy, right? They, maybe in that way they saw the future of it. Maybe in the way that they tried to stop it, but I wouldn't exactly give them credit for being, having a lot of foresight with new media.
I'm not trying to give them credit. I'm just sort of saying that there's been just an enormous conceptual shift.
Yeah, I think that's right too, and that's why I was trying to say it's like TiVo and I don't know. There's a lot of other things rolled into one. Was the Betamax? It blew people's mind. I hope I tried to make that clear. Yeah.
I just wanted to add something about the Betamax case. It was actually reheard, so the case was heard twice, and it was a really close case.
Right, it was 5-4.
Mr. Rogers actually came in and testified There was a big
Fred
debate as to
Rogers, yeah.
whether time shifting, so whether when you take a show and record it and watch it later, whether that should be fair use. And he said that he would be happy. There's a really great quote from Mr. Rogers, if people would tape his show, and that it would be beneficial to families, and that it would be a positive thing. And some people actually attribute the case, I'm not sure it was entirely all his testimony, but to Mr. Rogers and the fact that he said that people should copy
I mean, he had,
the show for personal use and watch it later on. So. Mr. Rogers may have shaped the history of technology today.
Is his testimony on YouTube?
no, it's testimony. You can find his,
You can find the text.
his briefs.
In the ruling, they quote the text
Yeah.
of his testimony.
Cool. Anything else?
I'll make just a general comment, but I'd say 76 was a key year. 76 was also the year of like punk rock and you know, general cultural movement. You know, the fact that that what he was talking about, that how copiers and in fact cassette tape duplicators and these things only became available in the mid-70s, is what allowed the rise of indie music all around, and that people could self-publish, and that, you know, even before the internet, and a lot of these things were worked out. You know, it gave the rise to sort of indie publishing.
In a way that even the audio tape and the Betamax were a lot more graceful for the content industry to adopt. I mean, the internet represents a really fundamental shift in the not only the ability to share media, but to produce it yourself, and to have, it's kind of like, you know, the audio tape, you know, had a superhighway that.
And what I'm talking about is like bottom-up culture.
Right.
Previously, top-down was the only way that you could go.
Precisely, and I think a lot of the things that are the most exciting part about the internet is a bottom-up culture, and people kind of working together to create new things and work together. But I'll be talking about that on Wednesday, so there's lots more examples there.
Thank you.
Yeah, thank you.